Hi, this is attorney Stephen Terpak from Sutter and Terpak. We're an employment and personal injury law firm located in Fairfax County, Virginia. And this is our video newsletter. The topic of today's newsletter is maximizing your recovery in personal injury cases, the fun activity liability waiver. I have an email here which I'd like to go through with you, but before I do, I have to give you the disclaimer. This newsletter does not constitute legal advice. There's no substitute for a one-on-one consultation with an attorney licensed to practice in your jurisdiction. So let's get into the email. Hi, Steve. Last weekend we went to one of those trampoline parks for a neighborhood kid's birthday party. Can't think of anything worse. And before my child could participate, I had to sign a liability waiver. Well, probably what you're into is one of those iPad liability waivers that you didn't read and try to do as quickly as possible. The email goes on, the place was mayhem. Luckily, no one was injured, not that you know of, but it got me thinking, what would happen if there was an injury? Is the trampoline place off the hook? Well, I think this is a really good question, and what we're talking about here is a pre-injury release or liability waiver. And the law in Virginia is pretty clear, of course with caveats, but it's been clear since 1890 that pre-injury liability releases are not enforceable and are void as against public policy in the state. Generally speaking, you can't sign your rights away in advance to sue a negligent party. So if the trampoline park is negligent, you can have a successful case regardless of a pre-injury liability waiver. Now, though, we have to move on to what's called an indemnity agreement. And some of these contracts or liability waivers may include those. Indemnity agreement is a contract between two people that states who is ultimately responsible to pay a loss. It would say something like Party A agrees to indemnify Party B if Party B pays on a negligence claim. So how would this come into play at the trampoline park? So the waiver that you sign on the little iPad may say that the child's parent agrees to indemnify the trampoline park for any negligence resulting in the child's injury. So would this be valid? And I think probably not. First, there's no way that it would stop a lawsuit, so the child would still have a claim to sue, which couldn't be stopped simply by this waiver. The kid could win a judgment or get a settlement. And furthermore, the cases in Virginia talk about diminishing recovery or eliminating recovery and that it's not allowed. So that would seem to be the case here. Essentially what would be happening is the child's claim would go forward, they would get a settlement or judgment, and then perhaps the trampoline park would say, well, wait a second, the parent agreed to indemnify us, we're going to sue the parent to get paid back. And I don't think that would be valid because of the case law, which states that these types of agreements can't eliminate or diminish the recovery. And I think putting in one pocket, taking out of the other pocket between the parent and the child would essentially be diminishing recovery, and I do not think that would fly. However, the trampoline park could have an indemnity agreement with somebody else, say for example the trampoline manufacturer, and that indemnity agreement may say that the trampoline park could sue the manufacturer of the trampoline to indemnify it for claims made because of negligence involving the trampoline. Of course, there's always a couple caveats. This is the law, and I'm going to discuss a couple of them. One of them is related to horse activities. The law says that if a parent signs a waiver, that's literally signs a waiver that fully informs them of the inherent risks of horse activities, then the parent and child can't win a negligence case against the horse program, but could still win for intentional type activities. So no negligence, but intentional acts, yes, you can still win against. However, if you don't sign that waiver, then you can still sue for negligence, the parent or the child. And finally, there's a case in a lower court in Virginia A lower court is like a trial court, not an appeals court, so it doesn't carry precedential value. But nevertheless, it's cited widely and referred to widely in these kinds of cases. And it is in relation to a race car driver suing a racetrack after he crashed into a guardrail and was injured. He had signed a waiver and he had agreed to inspect the track before racing on it. He sued, he raced, crashed, was injured, and then sued, and his case was kicked out. But I think this case is totally different from a trampoline park or something like that, because he was a race car driver. That is a serious undertaking. It implies that you know all the risks involved, and this guy had agreed to inspect the track ahead of time, and the thing that he sued for was really related to the track design or negligence in the track itself. So he agreed to inspect it, presumably did or had the opportunity to, crashed, and then blamed them for having a faulty guardrail. And that did not fly in front of this lower court. I think this is totally different than a trampoline park and a zip line. So if you have a question about a Virginia legal case, you may call our office and book a one-on-one consultation with one of our attorneys. For personal injury cases, we offer a one-on-one free consultation for a half hour. You can also email us your questions at info@sutterandterpak.com. Thank you for watching our video newsletter, and I will see you next time.